Well, hello and welcome to this webinar on intercompany agreements for transfer pricing compliance, focusing on intangibles and intellectual property. So this webinar is really for tax and transfer pricing professionals who need to help the corporates that they look after to actually implement their transfer pricing policies. And it's also for in-house lawyers who are involved in this kind of project and want to understand the background and what it is that they're being asked to do. My name is Paul Sutton, and I'm one of the co-founders here at LCN Legal. And what we're going to cover on this session, we've divided it into 4 parts. So part 1, we'll just go through the basics of intercompany agreements and what the transfer pricing guidelines say about intercompany agreements. In part 2, we'll use a mini case study involving software just to go through the basics of scoping and drafting intercompany agreements involving intangibles and IP. In part 3, I'll explain how we help, how we work alongside transfer pricing professionals on this kind of project. And in part 4, I'll just leave you with some additional information and where you can find it. So before we start, a little bit about LCN Legal and who we are. So we're a corporate law firm. We happen to be based in the UK and China, but we work with corporate groups throughout the world, as shown on this map. We are corporate lawyers by background. We're not tax advisors, so we work very much hand in hand with tax and transfer pricing professionals. We specialize in large cross-border group restructuring projects which have a strong transfer pricing element. And we happen to be the world leaders in intercompany agreements. So last year in 2019, we published what I believe is still the only book on this subject, a practical guide to intercompany agreements for transfer pricing compliance. And really our mission here is to bridge the 2 worlds of tax and transfer pricing, because so often these important areas, in particular legal implementation of transfer pricing, just falls between those 2 stools of tax and legal. So we aim to bridge those 2 worlds by providing practical tools and information. So let's dive into the first part of this session. So we'll go through what are ICAs, what do the OECD's transfer pricing guidelines say about contractual risk, and we'll go through some of the basics of backdating, typical mistakes, and key objectives. So what are ICAs? They're simply legal agreements which define the terms on which services, products, financial support, and licensing of intangibles are provided between associated enterprises. So maybe you're very familiar with the typical examples of central support services, strategic management services agreements, and so on. And in the field of IP, obviously this covers things like R&D services agreements and IP licenses, but also software licenses and distribution. So what do the OECD's transfer pricing guidelines say about intercompany agreements? As you may know, the TP guidelines actually contain extensive reference to contractual assumption of risk and the role of contracts in delineating or defining intercompany agreements. And in particular, in terms of BEPS compliance, what the TP guidelines say is that master files must contain a list of important agreements relating to intangibles, and local files must contain actual copies of all material intercompany agreements. And what this means in practice is that very often one of the first things that tax administrations do when they're conducting a TP audit is they ask for copies of intercompany agreements. And where there are gaps or defects in those intercompany agreements, it's an obvious point of focus for those tax authorities, and it immediately puts the relevant corporates on the back foot and exposes them to unnecessary costs in dealing with those inquiries, and very often unnecessary fines and penalties and adverse adjustments. One of the key features of intercompany agreements is the ability to deal with the contractual allocation of risk between the parties. And obviously risk and the allocation of risk is a key focus in terms of transfer pricing analysis generally. And one of the key points which is emphasized time and time again in the OECD's guidelines is the fact that risk is inherently linked with timing. And I've just included on this slide a quote from the TP guidelines, which says, the purported assumption of risk by associated enterprises when risk outcomes are uncertain is by definition not an assumption of risk, since there is no longer any risk. So this is exactly the same as the fact that you can't bet on a horse race after the winner has been announced. Equally, you can't allocate risk contractually in any meaningful way after those risk outcomes are known. So what that means in practice is that to the extent that the transaction type involves allocation of risk contractually as a key element, for example, limited risk distribution structures, you just can't backdate those types of transactions and expect that backdating to be effective from a TP perspective. So in other words, the longer that a group is left in the position that a key transaction is not documented by appropriate intercompany agreements, the greater the risk. So just from a high level perspective, what are we aiming for in terms of intercompany agreements and legal implementation of transfer pricing? Well, I guess you could just say, well, it's like any type of tax planning or tax compliance. Clearly, it would be unthinkable to, for example, plan a group restructuring project with a detailed steps plan and tax analysis and then not implement that in legal reality. Well, exactly the same applies to transfer pricing. So what we're trying to create here is transfer pricing policies which don't just exist on paper, but which actually are reflected in legal reality. Conversely, it means aligning the legal structure as far as possible with tax and transfer pricing policies. It means strengthening corporate governance, in other words, respecting the fact that a group is comprised of individual legal entities, each of which have their own officers with their own personal fiduciary duties towards those legal entities. And ultimately, this whole exercise is a failure, and if we haven't achieved the result of tax audit ready intercompany agreements. In other words, those agreements which support rather than undermining the TP policies are actually signed, available to produce on short notice when required. Typical ICA mistakes, something that we see time and time again within even very large and sophisticated groups, is intercompany agreements which simply don't match the transfer pricing policies in terms of the scope of transactions or scope of suppliers. The pricing provisions don't match. The agreements lack legal certainty and therefore under many legal systems are not in fact binding agreements at all. Intellectual property flowing in the wrong direction, fraudulent attempts to backdate transactions, and so on. So this kind of situation, I think, was, to be honest, it was prevalent based on our experience, and is now part of something that is very much a leveling up of standards across the transfer pricing and corporate industry, part of which is caused by the trickle-down effect of BEPS and advisors actually coming to grips with what this means in practice. So part of our mission here at LCN Legal is really to rescue corporate groups from shoddy and ineffective legal implementation of their transfer pricing policies. So I'm going to move on to part 2 of this webinar, and we're going to talk about scoping and drafting of intercompany agreements for transactions involving IP. And as part of that, we'll go through a 6-step process for managing intercompany agreements. We'll use a mini case study involving software as a service. We'll go through some key scoping questions for this type of transaction, and leave you with some key drafting points. So this slide is really to give you an overview of one way of looking at the overall processes for creating, implementing, and managing intercompany agreements. Step one is simply scoping the transactions, in other words, analyzing the key transaction types in the context of the group's transfer pricing policy. Step two would be the detailed review of the relevant documentation, which would include the draft transfer pricing policies, but also any existing intercompany agreements and the group structure. Step three would be drafting or creating discussion drafts of template agreements for each of the key transaction types. Usually within the group, there are 3, 4, or 5 key transaction types that really together explain and define the nature of the intercompany transactions, the key intercompany transactions, which together explain the transfer pricing policies. And clearly an objective here is to create an appropriate template agreement for each of those key transaction types. Step four is to finalize those draft template agreements and to make sure that the key stakeholders, the key issues within the group are fully represented. So as we all know, intercompany agreements are not just about transfer pricing. There are other key stakeholders such as customs duties, VAT, asset protection, IP protection, and so on. So that the step four is all about understanding from a holistic perspective the needs of the group in terms of the intercompany transactions and obtaining that input. Step five is about implementing the agreements, in other words, rolling out and adapting those templates across the relevant jurisdictions and legal entities. And a key part of that is actually briefing notes for the directors of the relevant entities so that they're not just being involved as a rubber stamping process, but actually the process is respecting their role in reviewing, considering, and approving the arrangements. And then step six is really the ongoing process of regular review and updating of intercompany agreements to reflect changes in operating models of the group, changing in transfer pricing policies, changes in the group structure, maybe following acquisitions and so on. So that's an overview of typical processes. So here's where I'd like to just talk briefly about a mini case study just to illustrate the thought processes involved. And here what we have is a simplified group structure showing a group which provides software as a service. So in this case, we have the parent entity as the principal IP owner, also as the principal entrepreneur within the structure, and is using local subsidiaries S1, S2, and S3 in order to distribute the software as a service. And on this diagram, we have S5, a subsidiary which carries out R&D activities in terms of developing and maintaining the software. So the objective of this scoping stage of a transfer pricing intercompany agreements project is really to identify the key transaction types involved, as I mentioned on the previous slide, so that we are creating template agreements for each of those key transaction types. So in this example, aside from licensing of IP, there will be services provided by the parents to the subsidiaries, which include things like back office support, strategic management support, and so on. You'd expect there to be loan agreements, so in the way that the group as a whole is funded. In this case, it's by the parent entity, but in many groups, there will be FinCos, so financing entities within the group, and other entrepreneurs will provide loans according to the group structure. In this example, there's a provision of R&D services by S5 to the parent, so that would have its own category of template agreements. And of course, there will be the IP licensing agreements. Um, in this case, it's a license from the parent companies to S1, S2, and S3, and those individual companies in this example are acting as principals in terms of providing the software as a service to the local customers. So from a high level perspective, what are we looking at in relation to the intercompany agreements and the design of those agreements? We're looking at the nature of the intellectual property rights. In other words, if we're talking about software, what we may be looking at from a legal perspective is a bundle of rights, including trademarks, rights in passing off, copyrights, maybe patents, rights in databases and user data, confidential information, and so on. We'll be looking at the legal, beneficial, and economic ownership of the relevant intangible assets. And here, one of the key issues, one of the key challenges is, of course, that lawyers and transfer pricing professionals, in reality, they speak a different language here. So from a transfer pricing perspective, the focus is very much on the DEMPI function. So which entities in the group carry on the functions of development, enhancement, maintenance, protection, and exploitation of the relevant intellectual property rights, and that is a fundamental part of the analysis as to which entities are entitled from a transfer pricing perspective to receive the benefits of that exploitation of those intellectual property rights. Whereas from a legal perspective, generally speaking, the focus is on which entity is the legal owner, so that includes the owner, the registered owner of IP, and which entity is the beneficial owner of those rights. And where there's a disconnect between beneficial ownership from a legal perspective and economic ownership from a transfer pricing perspective, that can cause real difficulties in implementation of transfer pricing structures. So if at all possible, it's important to achieve an alignment of those two considerations. Moving on, in terms of the bullet points, in terms of licensing of intellectual property, it's very important to distinguish whether the license is for the licensee's own internal use, or whether this is a license which is more in the nature of a distribution or sub-licensing arrangement, so that the licensee is granting further sub-licenses to third-party end users, because obviously that will be a key term and a key part of understanding the economic relationships. Contractual model we've already touched on, and here in this diagram, the distinction would be between S1, for example, on the one hand, and S4 on the other. So in this example, S1 is acting as principal in entering into contracts with third-party customers, whereas S4 is merely acting as a sales agent. So in relation to S4's territory, contracts with third-party customers are actually entered into by the parents directly as principal. And this is one example where functional analysis, in other words, who does what within the group, clearly can never describe the full picture of how the economic arrangements work, because you do need to have that understanding of the contractual model in understanding how the risks are allocated. In other words, in S4's example, if S4 is merely acting as a sales agent or introduction agent in terms of identifying potential customers, and the parent is then entering into the actual license agreement with those customers, then S4 would not be expected as a default position to carry any product liability type risk or credit risk or whatever. Whereas for S1, S2, and S3, the default position would be if those entities are actually contracting with customers, then those customers would have recourse against S1, S2, and S3 respectively. And that risk would only be passed back to the parent if if that allocation of risk is actually legally achieved through the intercompany agreements. And as part of that thinking, it's important for the function of intercompany agreements and the legal strategy to be looked at from a holistic basis. So, for example, if part of the rationale for having separate legal entities in those different countries is to ring fence legal risk and to separate the ownership of the valuable assets, so the IP asset, from those market risks, then clearly that asset protection intention is going to be undermined to the extent that, for example, a limited risk policy is adopted, because by definition, de-risking S1 in this example would mean passing that risk back to the parent, in which case you can't have your cake and eat it. You can't de-risk the parent from that risk at the same time. So on this slide, we've just summarized some of the key scoping questions if you're looking at transactions involving the licensing of IP. I'm not going to read through all these questions on this right now, because you can read them just as well as anyone else. I'm just going to touch on some of those areas that have been highlighted in yellow on this slide. So in item 5, ability to sub-license, we've talked about this already. So this is the key part of understanding what is the nature of the arrangement. Is the license of IP provided for the internal use of that licensee entity, or is it in the nature of a sub-licensing and distribution type arrangement? Item 6, the proposed pricing method from a transfer pricing perspective and pricing terms. So where, for example, it's intrinsic to the transfer pricing analysis that the licensee is guaranteed a particular return in relation to its activities. So there's a guaranteed minimum profit margin, for example, then that guarantee actually needs to be stipulated in the license agreement as a legally binding term, along with the other provisions concerning pricing and payment, including currency, payment terms, default interest, and so on. Item 7, risk allocation. This goes back to the limited risk type discussion that I touched on in the previous slide. So part of the key risks that you're looking at here is the risk of IP infringements, regulatory compliance, product liability, or customer claims, and so on. So clearly this is an important focus. Item 10, related transactions. So what I'm really highlighting here is that in terms of the legal design of the overall structure, you can't look at one transaction type in isolation. For example, if you have a group which manufactures and sells goods, then one set of transactions may involve the licensing of trademarks to the local sales entity, and there may be a separate set of transactions relating to the sale of goods, in other words, the distribution type arrangements. And those transaction types will have different requirements and different third-party considerations, such as customs duty, VAT, and they need to be looked at as a whole, because together the IP license and the sale of goods arrangements will form the overall picture. And similar considerations apply to provisions of services, such as management services. So there can be some flexibility as to whether payments are rooted in the nature of service fees as opposed to royalties, and the structure may have implications as to issues such as withholding tax. So really here I'm just flagging the facts that you need to look at the design of the transaction types in a holistic way. Final point just to mention on this slide is the question of jurisdictions, localization, and translations. So And this comes in at the implementation phase of a typical project. So very often when you're talking about localization of intercompany transactions, the main focus is really on the pricing of those transactions, whether there should be, for example, be different royalty rates to reflect the different profit potential of the intangible assets in the relevant jurisdictions. In terms of applicable law, generally speaking, the key challenge here is to correctly define and delineate the transactions, and the choice of applicable law is not really a key consideration. So obviously, the agreements need to have legal certainty, and that means being clear as to the choice of law. But whether the law chosen is English law or US law or Swiss law, by and large, it doesn't really matter. And this is why we as English lawyers are able to provide value on transfer pricing projects, even if they have no connection with the UK. And that's because the main skill set is really correctly identifying the transaction types and expressing the commerciality of those transactions, and whether a draft agreement then needs to be adapted so that it is governed by Swiss law, for example, that's really a minor part of the work as compared to the overall design. So on this slide, I'd like to give you some key drafting points from our perspective, which I'll go through quite briefly. Number one, keep intercompany agreements as short as possible. This is something that we are really passionate about, and the main point here is that the longer the agreements are, the less likely they are to be read by the key stakeholders within the group, and therefore the higher risk is that they will not match what is happening in practice, in which case the integrity of the whole documentation is going to be undermined. Number two, we've already talked about aligning IP flow and IP ownership with the transfer pricing policies, and that may require some pre-structuring to deal with discrepancies in that environment, in that alignment. Point three, aligning contractual risk with transfer pricing policies. As I mentioned, this is something we see time and time again in the transfer pricing documentation of large groups. So, for example, they will describe a distribution arrangement as regards which entity bears product liability risk, credit risk, currency risk, and so on. And in order for that statement in the TP documents to be true, it needs to be reflected in fact in the agreements. Point four is achieving legal certainty in the arrangements, including on pricing. I think previously there was this misconception, this idea that pricing clauses should be kept as vague as possible. And that's why you used to see clauses which say that the amount of the royalty or the pricing of goods should be agreed between the parties from time to time. Now it's recognized that simply doesn't work, because under many jurisdictions, legal certainty on price, because it's such a fundamental term, is essential for a contract to exist at all. And if you don't have a contract, then you can't achieve a contractual allocation of risk, and therefore the statements about those transactions in your TP documents are likely to be wrong. Point five is to think of intercompany agreements as framework agreements. So the point here is that particularly for software, where it's probably going to be a fast-moving environment, there may well be a suite of new products which are released from time to time during a year. You don't want to create unnecessary updating of agreements each time a new product is launched. So what you're really trying to achieve in the intercompany agreements is a contractual framework within which those products can be licensed or those suppliers can be made. Point number six, avoid using traditional third-party agreements as the starting point. The reason for that is that very often agreements like that will contain a whole load of boilerplate, which may be standard in many third-party transactions, which are completely inappropriate from an intra-group perspective, and also because the allocation of risk reflected in traditional third-party agreements may be completely opposite to what is required. And so very often third-party agreements are just not a sensible starting point for your drafting work. Point 7 is to avoid creating unnecessary administration. So examples would be things like change control procedures within agreements which require notifications and consents and so on within the contractual arrangement. Really, this goes back to the framework agreement point and keeping ICAs as short as possible. It's important to avoid the need for unnecessary addendums and variations to those agreements as far as you can. Point number 8 is to anticipate what translations will be required. So this is a matter of looking at the footprint of the group and the relevant transactions, looking at the practical requirements of the tax administrations in relation to intercompany agreements. So which tax administrations will accept documentation in the English language, which will require translations, which require certified or even notarized translations, and to build that into the project plan. Final point 9 is really the golden rule for the design and implementation of any intercompany agreements and the design of the overall structures, is that you need to apply the common sense test. Does this make sense from the perspective of all the participating entities? In other words, is this an arrangement which the directors of each participating legal entity can properly approve as being in the interests of that entity? And it is shocking to see how many agreements and arrangements in the past have not met that test, but all it takes is that focus and discipline to apply a common sense approach to transactions. So I'm going to move on and talk about how we help in relation to this environment. So there's legal support we provide, the training and templates, and talk a little about our document automation platform. So in terms of how we help, we've set out the main areas on the slide. So one is what we call a traffic light review of existing intercompany agreements, and this is where we compare on the one hand, what the transfer pricing documentation says about those transactions. On the other hand, what the legal reality is based on the agreements already in place, and therefore there's just a traffic light system as to, green appears to be aligned, amber, there may be issues that may need to be dealt with, red, serious discrepancies, which in many cases may mean that the group needs to consider its historic tax filings and consider whether it needs to make voluntary disclosure to the relevant tax authorities on the basis that those filings have actually been misleading. Type number 2, design of intercompany agreements tailored for each transaction type. So here we're talking about creation of tailored template agreements for each type of transaction, which can then be rolled out. And very often we're able to provide fixed fees of this type of project, depending on the complexity involved. Type number 3 is the use of our document automation platform, which I'll come on to separately. Type number 4 is full service design, implementation and maintenance of intercompany agreements. So this is not just creating the template agreements, but also the full implementation, localization of those agreements, production of briefing notes and so on, plus ongoing maintenance of those arrangements. Type number 5 would be corporate structuring projects. So as I mentioned at the beginning, one of our key specialisms as a law firm is the legal design and implementation of large group restructuring projects with a significant transfer pricing elements, and this is working alongside tax and transfer pricing professionals. And finally, we also provide a virtual legal director service, which is really like a virtual secondment on a part-time basis of one of our senior lawyers to the client's team, and that's either to help on an ongoing basis in relation to a particular type of project. For example, there may be a larger project to update and implement revised intercompany agreements, or it might be providing strategic legal support for the group generally, including hands-on assistance on individual projects and issues as they arise. So in addition to actual legal support, legal advice, we also provide training and templates. So one way that we do that is through our online course in intercompany agreements. And what this is a 10-module course which participants can complete at their own time. It's delivered via webinar, so a bit like this one. And it goes through the basics, the background of intercompany agreements, goes into a lot more detail about what the OECD's transfer pricing guidelines say, and then looks at individual transaction types, so more detail about IP, but also things like services, supply of goods, and so on. We also provide bespoke training sessions for corporates. So very often this is bringing together the transfer pricing and tax teams with the legal teams so that we can help facilitate that discussion and clarity of understanding what is the challenge here, what are the issues to avoid here, what are the peculiarities of the group, and how to prioritize the project so that the project team is focusing on the transactions which carry, or transaction types which carry the highest risk from a transfer pricing perspective and make the biggest difference. And we also provide a toolkit of templates intercompany agreements. So this is based on our experience of advising in this space, and from my perspective, for over 15 years now. And over this time, through LCM, we've developed a set of template agreements which cover the key transaction types. As I mentioned before, as part of our focus on this area, we've actually developed a series of document automation tools. And what they're designed to do is to enable people to create effective intercompany agreements by answering a series of questions in an online questionnaire. And a key feature of that, or why we bothered to create this, is that what we noticed that in terms of the key questions, the key information that is needed to create a first draft of the agreement, this information is already at the hands and in the minds of the transfer pricing and finance teams, because they've already gone through the transfer pricing analysis at the initial stages. And so we've designed these questionnaires so that they don't require any legal knowledge, and are tapping into the information which they already have to hand. So the transaction types that we cover at the moment through these tools, it includes services charged on a cost-plus basis. So this includes things like central support services, but also marketing and R&D services and so on. Second transaction type is appointment of limited risk distributors or sales entities, which are remunerated on a transactional net margin method basis. And this includes software distribution. We cover lead contractor or support services agreements. So this is for groups which have a consulting type business model where there are multiple legal entities which may act as lead contractors for their local market, and internally they subcontract to other legal entities in other jurisdictions to provide fee earning type support. So really what these agreements are about is allocating that client fee income amongst the participating entities. IP licenses, so royalty type arrangements, that's a separate transaction type and a separate tool available. Intercompany loan agreements and intercompany debt documented through loan note instruments. We are regularly adding additional transaction types to respond to demands. So I expect in the next few months that there will be ones available for things like contract manufacturing, and cash pooling arrangements, and so on. So that completes part three. All I'd like to leave you with is where to find additional information. So if you'd like more information about our fast track ICA document automation platform, you can use the link there. If you've got any other questions, or if you'd like more information, then please feel free to reach out. You can use that email address, info@lcnlegal.com, and you can also find a lot more information at that website, lcnlegal.com, including various free guides, articles, and resources. So I hope you found that helpful. We'd be delighted to hear from you if you would require support or information. And I wish you a very good day. Thank you.